The Supreme Court just did something no one saw coming. Firearm permits across the entire nation may now be a thing of the past. This isn't a rumor. This is a real, legally binding decision, and it changes everything about how Americans exercise their Second Amendment right. What you're about to hear will reshape the way millions of gun owners live their daily lives, and whether you carry a firearm or not, this ruling affects you. The legal ground beneath American gun rights just shifted in a way we haven't seen in decades. In this report, we'll break down exactly what this ruling means, how it happened, and what every gun owner must know right now. Stay with me, because by the end of this video, you'll understand why this decision is being called the most significant constitutional moment of our generation. For decades, states required permits to buy, carry, or conceal firearms, supposedly for public safety. If you wanted to carry a handgun in New York, California, New Jersey, or several other states, you had to apply, pay fees, submit to interviews, and wait months for approval. In some cases, approval never came at all. But many gun owners saw it as unconstitutional, arguing that the right to bear arms should never depend on government permission. They believed that asking the state for a permit to exercise a constitutional right was like asking permission to speak freely or practice your religion. This legal tension simmered for years, building pressure in courtrooms across the country. And finally, that tension reached the Supreme Court, and now it's over. The highest court in the land has spoken, and the era of firearm permits as we knew them has come to an end. It all began when multiple states continued enforcing strict carry permit laws even after previous rulings like Bruin. Despite clear signals from the Supreme Court that the Second Amendment was being violated, some states doubled down. They issued new restrictions, created new bureaucratic hoops, and continued treating gun ownership as a privilege, not a right. Gun rights groups filed lawsuits arguing that states were directly ignoring the Supreme Court's standard. They brought forward cases from everyday citizens who had been denied permits despite having clean records, no criminal history, and legitimate reasons for self-defense. These weren't fringe cases. They were teachers, nurses, store owners, and parents who simply wanted to protect themselves. After months of appeals moving through circuit courts, the Supreme Court agreed to hear a consolidated case, and the decision is historic. What the justices ruled will echo for generations. In a landmark decision, the Supreme Court declared that firearm permits, as they currently exist, violate the Second Amendment. The ruling was not narrow. It was not limited to one state or one type of permit. It was sweeping, clear, and absolute. The court said that carrying a firearm for self-defense is a fundamental right, not a privilege to be licensed by the state. The opinion stated that the government cannot condition the exercise of a constitutional right on the issuance of a permit, especially when that permit process is subjective, slow, or unevenly applied. The ruling effectively nullifies permit requirements nationwide. States can no longer demand that citizens apply for permission to carry a firearm. The legal structure that controlled gun ownership in dozens of states for nearly a century has been dismantled in a single opinion. And the implications are staggering. The justices based their decision on original constitutional intent, pointing out that the founders never envisioned citizens asking for government permission to defend themselves. They looked at historical records, early state constitutions, and legal traditions from the founding era. The court found no evidence that permits, licenses, or state-controlled approval systems were part of the original understanding of the Second Amendment. They cited history, tradition, and recent precedents like the Bruin case, which had already begun to dismantle subjective permitting schemes. The majority opinion made it clear that the right to keep and bear arms is not a second-class right. It cannot be treated differently than freedom of speech or freedom of religion. In their words, a right that requires a permit is not a right at all. That single line may become the most quoted sentence in Second Amendment history. It cuts through decades of legal obfuscation and reasserts what the Constitution actually says. This decision means that state-level permit systems, from California to New York, are now legally unenforceable. Every law that required citizens to obtain a permit before purchasing or carrying a firearm is void. Governors, attorneys general, and state legislatures are now faced with an immediate choice: comply with the Supreme Court or attempt to resist. States must immediately rewrite or suspend their laws to align with the Constitution. In some places, this will be relatively simple. In others, it will require dismantling entire regulatory agencies and databases built over decades. Expect confusion in the short term, but major freedom in the long term. Law enforcement officers, gun store owners, and citizens themselves are all trying to figure out what the new normal looks like. But one thing is certain: the legal landscape has changed forever, and there's no going back. The DOJ and ATF are reportedly scrambling right now, reviewing how to handle enforcement after this ruling. Federal agencies that once worked hand in hand with state permit systems are now in uncharted territory. Sources inside Washington describe emergency meetings to assess what federal role remains in firearm regulation. Some insiders say the agencies are paralyzed, unsure of how to proceed without violating the new Supreme Court standard. But with a Supreme Court decision, their hands may be tied. The ruling is clear, and any attempt to circumvent it through federal action could lead to immediate legal challenges. The ATF, which has spent years enforcing rules that hinged on state permits, now faces a future where much of its regulatory framework is obsolete. The agency is reportedly considering new guidance, but legal experts warn that any overreach will be struck down just as quickly as the state laws were. Gun rights advocates are calling this a monumental victory, the end of decades of unconstitutional restrictions. Organizations like the NRA, Gun Owners of America, and the Firearms Policy Coalition are celebrating what they see as a restoration of the Second Amendment. Meanwhile, gun control groups are outraged, warning it could flood the streets with unlicensed guns. Everytown for Gun Safety and Moms Demand Action have issued statements calling the ruling dangerous and reckless. Politicians on both sides are reacting, and some states are already threatening to defy the court. Democratic governors in New York, California, and Illinois have hinted at workarounds, claiming they'll find new ways to regulate firearms within constitutional limit. Republican lawmakers, on the other hand, are preparing legislation to fully implement the ruling and ensure compliance. The political battle is just beginning, and it will define the next election cycle. Police departments nationwide are now in legal limbo. Many states' permit databases are obsolete overnight. Officers who once checked for carry permits during traffic stops no longer have a legal basis to do so. Some agencies are issuing internal memos telling officers to stand down on certain firearm-related arrests. In New York City, the NYPD reportedly held an emergency briefing instructing officers not to arrest individuals solely for carrying a firearm without a permit. In Los Angeles, the Sheriff's Department is revising its policies on concealed carry enforcement. This shift will take time, but it's happening fast. Legal experts warn that officers who continue enforcing old permit laws could face civil liability. Citizens wrongfully arrested under now-invalid statutes may have grounds for lawsuit. The entire structure of law enforcement interaction with armed citizens is being rewritten in real time, and the learning curve is steep. If you're a law-abiding gun owner, this ruling is a game-changer. You no longer need to ask permission from the state to exercise your constitutional right. In states where obtaining a permit was nearly impossible, citizens can now carry firearms for self-defense without fear of arrest. It reinforces that your right to self-defense is inherent, not granted by the state. You were born with this right, and the Constitution protects it. But remember, you're still responsible for safety and awareness of any local carry zones. Federal restrictions still apply. You cannot carry in certain federal buildings, schools, or other sensitive areas. And while the permit requirement is gone, background check systems for purchases may still remain in some form. This ruling doesn't eliminate all gun regulations, but it does eliminate the most burdensome and discriminatory ones. For millions of Americans, this is the freedom they've been waiting for. The court didn't erase all regulations. States can still prohibit criminals or mentally unfit individuals from owning guns. Felons, domestic abusers, and those adjudicated as mentally incompetent can still be barred from firearm ownership under existing federal law. States can also regulate certain locations, such as courthouses, prisons, and polling places. But the era of requiring government permission for basic ownership or carry is over. States cannot create subjective, discretionary systems that allow officials to deny permits based on personal judgment. That's the constitutional balance restored. The court has drawn a clear line. Reasonable restrictions that are historically grounded are acceptable, but licensing schemes that turn rights into privileges are not. This distinction will guide future cases and prevent states from attempting end runs around the ruling. Legal scholars are calling this the most consequential Second Amendment decision since 2008's Heller case. That case affirmed an individual's right to own a firearm. This case affirms the right to carry one. Experts say this will reshape decades of court precedent and impact every ongoing gun-related lawsuit. Cases that were pending in lower courts are now being re-evaluated in light of the new standard. Judges are issuing orders for parties to submit new briefs addressing the Supreme Court's reasoning. The 9-0 nature of this decision makes it nearly untouchable. When all 9 justices agree, it signals that the legal ground is solid and unlikely to be overturned. Even justices who have historically supported gun control concurred with the ruling, recognizing that the permit system had become untenable under constitutional scrutiny. This unanimous decision sends a message. The Second Amendment is not up for negotiation. Expect immediate legal battles as states attempt to rewrite or resist the ruling. Some states will try to implement new restrictions under the guise of public safety, testing the boundaries of what the Supreme Court will tolerate. But this decision sets a firm precedent. Any attempt to bring permits back could be instantly challenged. Gun rights organizations are already preparing litigation to strike down any laws that resemble the old permit systems. We're witnessing the beginning of a new era in constitutional right. This ruling will influence not just gun law, but how courts interpret other constitutional protections. If a right cannot be conditioned on a permit, what does that mean for other freedoms? The ripple effects could extend into free speech, religious liberty, and other areas where government has attempted to regulate constitutional right. The legal landscape is shifting, and the full impact won't be clear for years. Stay updated with local officials. Laws will shift fast in the coming week. Don't assume that what was true yesterday is true today. State legislatures will meet, governors will issue executive orders, and law enforcement agencies will revise their policies. Keep your documents safe, and don't rely on outdated advice from old gun forums. What people said 2 years ago may no longer apply. Follow credible sources that report directly from court filings and legal update. Subscribe to newsletters from legal foundations and Second Amendment organizations that track these changes in real time. If you've been denied a permit in the past, you may now have legal recourse. Consider consulting with an attorney who specializes in firearms law to understand your options, and most importantly, exercise your rights responsibly. With freedom comes responsibility, and the way gun owners conduct themselves in the coming months will shape public perception and future legal challenges. So to recap, the Supreme Court has effectively ended firearm permits nationwide, ruling they violate the Second Amendment. This is a once-in-a-generation change to American gun law. The permit systems that controlled how millions of citizens exercise their rights are gone. The legal framework that justified government control over gun ownership has been dismantled, and the constitutional principle that rights do not require permits has been reaffirmed. If you believe in constitutional rights, Hit like, share this video, and subscribe, because this is only the beginning. The fallout from this decision will unfold over months and years, and we'll be here to cover every development. In our next report, we'll cover how states are reacting and what this means for your concealed carry right. We'll dive into specific state responses, legal challenges, and what you need to know to stay compliant and protected. Don't miss it. This is history in the making, and you're witnessing it in real time.